Mame fa say ma PENDREAM TV. PENDREAM TV there osia dem yopo.
So if you have been following the political development in this country there, we are quite familiar with the popular Wontumi case and then Sednam Tamaklo's repatriation into Ghana. These are trending issues, COSO, and today I'm going to take my time. Earlier, that was yesterday, we had opportunity on Joy Prime to discuss this particular issue, but it wasn't extensive because time has always been limited. So very often how you want to take your time, break the issues down for people to understand, so very often I use this particular platform to take my time, break the issues bit by bit to harness understanding, deeper and a comprehensive understanding. Sebeya wonso no ubetimi use as a building blocks. Now analyze it, now what use to build your own political consciousness. I don't want to build your political consciousness for you, but I can give you the raw material, the building blocks are here, which is information that is factual, unadulterated, that is unblemished. You situate it within your own context, synthesize it, make informed decisions and political choices out of it, and that is our job. So we hear issues now, especially the Wontumi case comes in twofold. There is one koswa, your friend is saying trial na koswa next month on the 3rd. The judge now indicates so the ruling beba. That particular case is different. So the operation recover all loot and then as a phenomenon, despite the fact a lot of people said they no. There are a number of cases going on in court. I can authoritatively and confidently tell you, sir, there are a number of cases COSO various courts. And your friends, Attorney General is also preparing other dockets. And then as a former in the coming days, a lot of them will be going to court. But you see, the way the criminal justice system no city, if you are charging Obi in a criminal case, you have a duty as a prosecutor to prove beyond every reasonable doubt any case be a so it's not something I could court no. The accused person may decide not to even talk at all. Even with that, if you are unable to produce evidence, prove your case beyond reasonable doubt, the accused person will go home. Or no, he has nothing to prove except in few situations, and the burden will shift to the accused person to discharge or nankasa prove a based on retino. By many of the instances in another burden of proof resting on the prosecution. Sebe or find the accused person guilty. So not trial involving criminal cases, and yeah, easy road just like that. So sometimes a little bit patience and then as a forum will get us there. And that is how it is. That is the system. You can't do anything about it. But the commitment on the part of the government there, I think that has been demonstrated so far. And many of the cases going on in court. And to me, one of the leg of the case, and I one and the lawyer and that wababontin, I will say I will draw a free that particular case as a would see radio interviews and then as a far and I'm a catcher say he's talking with a certain defeatist muzzles. You can't defeatist muzzles. I say, I dare not wo and why wouldn't say any ye. And to my memfa patapane, your friend say, and to come from and this uncle people will not blame me. That is exactly what he's doing because and then me can or Joy Prime say, or fairly notice say, or withdraw as Wontumi lawyer no. We're granting more interviews than he has even represented Wontumi in courtroom and then and then now because motive or motive in one only say the evidential value in the ongoing case can be proven beyond reasonable doubt, and if that is the case it means that the client would definitely be convicted by court in whatever form shape I can't tell. What who say we the only way I obetime yi ne ho afrim anabama amanfo because whenever issues bana we na NDC MPP awie enti waba abonten prepare amanfo minds for the west enti eba the obeya na say yanka nkyira mo say Wontumi no omo plan say omo de ne betum because enye interesting say lawyer wadi obi asem a follow na ma aka few days ya di asem ni nyina wie baby a judge no bia no or throw no ruling na wo ka kire court say wo withdraw services. The question is time na na ekoso ni nyina no de na wo ye and nsem na wo kan de ntia enni nyina so papa no maka kire say and Appiah Kubi is one of the people I respect so much, or you be okanadwen, and I have a lot of admiration for him, and I disagree with those who say he's not a good lawyer. But there's circumstances in as if one find itself in, I don't know why, but the thing is that a bra case no cost no. So no one some na okay can say judge near bias, say judge your bias, nasa way a senior lawyer, you know what to do. You can petition the Chief Justice. And for judges on recusing home, and that will not be the first time such incident in the AC. Obakaya Dr. Opuni case in as for similar instances a play out to us or reasons are a solid ironclad a judge no a biasa. There are avenues a bit me and there is this trivial issues or tugum from mamze or the motion square na judge na buatwagu na when a casa or court you could do a semina or fale at the chin chance court no engentum. The court rules when it comes to admissibility of evidence or whatever. Judge and exercise sole discretion. You as a judge, as a lawyer, wait me but the final authority arrested with a judge to make that final determination as to whether whatever you are filing never go through. And now we know how many times a man for some and near my man for a file or court able to go. So these are trivial petty issues but and I'm saying politics in here very cheap. Media and also can easily allow some of this nonsense to go through Nintendo or two people will buy and people are discussing. So my point is that he has no point. They are all a PR campaign and are all running. I say we do Sika Koma radio station say and running advertisement. That is what Appiah Kubi is doing because he knows the case is very bad and he doesn't want to go down with Wontumi. So that say onke can sem wengum sebe ya a bad impact no because say oh NDC for buy or my target Wontumi no modna kwashem and the substance of the issue na nkasa kwado watwatwene and all double in trivialities then as a form. So for me I think say the yame yawo this case in him say he's somebody I have respected so much and it's really embarrassing say oh yeah dear oh ye senka or withdraw crackeke. And I say on kasanka that is fine. But while we draw away, I feel all granted interview mu atuguba moving from one radio station on namha and some more can you na say and he said say judge in a convent Wontumi be shameful on like a bayan one as a lawyer war case pending you and your emotions and about overshadow. It will be highly unreasonable to be making such prejudicial statement and then as a form because you are a party to the case. Until say your withdrawal, whatever goes on successfully, whatever you say, it must be deemed to be part of the case. So I think where the am say Neemano Afanudumum, and in the first place, I don't even know why ordered no for a case in the first place because Wontumi nam krom ha brabo bone we say waban ba power na nyansa ni utima wadwe ni say sikabu mekọ ha mbema me contract mekọ ha menya no you should know say a day will come you will be held to account and I am say adwene no na emu etia na adwene na emu no ntino onam ba bia gigigi sika na hwe edan ya Wontumi asi kumase edan no echen castle na obisa won say ahiafo mugu kumase omoye MPP fo a obi pe 20,000 kra dia starting ibetire no wanya bi cars na sefo Wontumi ato in the name so oye party national chairman na obisa say abrantie wasi so a wofe na wo bobra no wo sign na wunya free na ene wati manya kokodura kugina court dem say o ko fight am obi. Let us be smart and very intelligent. Sika no munya no, and it's not just Wontumi. That is the case with a lot of politicians. Very greedy, very dangerous. Onya obe feeding no ho even if a hona be hu amanfo ahoro. But the very people who deserve the help nankasa no will never be extended to you. Na achiri asemba ahia forma na siasa lie. Akoye dede na se fornum. I think we can be better than some of these things. So senka President Mahama ba ye and a one new Wontumi asem and a what time no what na to prisoner that yebeka ho asem. But once the right to free trial as espoused in article your friend is at 19.1 kasa obia wo right to free trial abema we enough time to prepare your case for defense then as for no ni nyina no Appiah Kubi nyanka ne baby say ye deny no because these are human right provisions say at any point in time we free say ye tietia so there are several other means of it even seeking redress because article 33 make it quite clear a safeguarded and a protected the fundamental human right espoused in the constitution. So as a lawyer he knows all these things, but the questions I didn't there on them radio so run the commentary, emotional commentary, just tactics in the crocodile the journal on them no for so for and the Appiah Kubi the respect. And I can notice a lot of people are disappointed in him because people respect him a lot. Now, here treatment if you want to many MPP for then the fast will chroma then as a former. Nasa Aqua just say way I show that, and that is up to him. But I'm very much disappointed in him because I really like him. I really like and admire him, to be very honest, because I like people who are very frontal, to become one or can who be. Ene MPs no mko kachira Kufuado say Kendoforata ebo MPP form enti onyi no free ho na omotu omani si no so eye ya na olusu ni seat ema your friends an independent candidate ba beje that particular seat na ene ehon so say okay from pop beje sa seat na no so ehon sama be tag of war no enti sa na tie. Then there is another interesting way assign course within the media space and then me who papa be say friend hwan bentel or a lawyer na hwan yes and your friend say Wontumi the lawyer ya and the Appiah Kubi na say for no about this plea bargaining thing their point in say obi kose or kwakwaje plea bargaining na enkyere say nipa no edifo and no be kai e joy anopa ya enra awa ene na say for the same unnecessary arguments na no mu make. And why I feel so disappointed ne say Friday, announced a day before Friday. And the Appiah Kubi, any OB, the two no lawyer and lawyers and on multi platforms and they were discussing this particular matter. Appiah Kubi was bold enough to say, we'll go for plea bargain. It's not an admission of guilt. This is not a matter of opinion. This is a matter of fact. And I'm saying an authority said that is a lie. So I was expecting the journalist to correct him. Said no. Sasem na okano. First no kra na your friends say plea bargaining act in your you could assume, but the plea bargaining act provides certainty. Say you will plead guilty along the process, and yes, sir, there will be no plea bargaining. So for a lawyer of his caliber to go on radio and be saying, say, and I have listened to a lot of lawyers on various platforms, and sometimes it's really shocking and very embarrassing when we are watching from a distance. And today I'm going to prove everything to you. My catcher said, these things we do is not based on conjecture. It's not based on anything. If anybody is saying anything which is not true, it doesn't matter whether the person is Chief Justice or Memeti Hai, Opa Kofa Supreme Court, Diana Rigu Yemna Fabra. If you are arguing and you don't make sense, you are lying, we will expose you. It doesn't matter na mena meya hwan opa kofa Supreme Court na faswa wuti na fananam. If you lie, you lie. And that is the point we are making. So you can't plea bargaining and then there my culture say our history, not from Ghana. Plea bargaining as a concept started here in America somewhere in the 1800s. Abra na judges and for no musa na cases no baby. So even started with prosecutors and accused person na judge na nkasa kra nka ho. So ebedru judge no ho no na o settle issue na we the judge will only give a finality to it. So that is how it started. Until they were negotiating guilty plea. Oh, body no na okotwa me na mkotwa cost ne say cost ne your friend say 500. We don't want to go through this back and forth until no there to 400. Na your friend say yenye enko kanchire je waje to bobetua. So that is how the settlement was going. Then even when it started in America at the time, people kicked against it because no free say infringe on I say impugning on the principles of justice and then I say for and accountability. But quickly now spread your true Commonwealth jurisdiction and civil law common law jurisdiction and civil law jurisdiction and I spread the eye and I could we see baby. So that is how it started. Into Ghana, yeah, the first time ADFN plea bargaining was introduced into our laws. 1993. 1993, that is the Court Act. And no, and I introduce you plea bargaining into our your friend saying emra I will chroma say and this all section 35 of Act 459 the Court Act now it's quite clear explaining in details kwanya your friend is saying idea your friend plea bargaining. I'm saying that the first time it was introduced into our laws, you know, the year 1993 and 1993, no. And I don't want to mix anything, you know, maybe section 35 of the Court Act and say 1 or say where a person is charged with an offense before a high court or a regional tribunal, the commission of which has caused economic loss, harm or damage to the state or the state agency, the accused may inform the prosecutor whether the accused admits the offense and is willing to offer compensation or make restitutions and reparations for the loss, harm, and other damages. So the key and the central point, even in the early stages, now, your friend say Act 35, 7, Section 35 of Act 459, no, whether the accused is willing to admit the offense. Come my culture say the plea bargaining provisions stem from must conform to a constitutional provision, say presumption of innocence until proven guilty. That is the only way any court to be an answer or mine, and answer the state can punish somebody. Until whether the person is proven guilty by the court or the person himself accept guilt, you know, that person can never be punished. And this is what was established in this particular provision. It looked hazy. So over the years, you know, as time goes on, no, then other provisions came. So we came back 2017, that is when the Special Prosecutors Act was introduced. And also no, Section 71, the same thing, plea bargaining. And they expanded, no, the same economic way na kasana na wasem sika or afa kwabrandin satem na your friend say I go waste in as a form no kwan ye fa so a whether the person will pay restitutions every state in benya na as a form no. Section 71 of your friend said the Special Prosecutors Act no so no outline the modalities and ninyina so no kase you must first admit guilt. But me say me hu no ha nka I will read such portions of it. Na what is say Special Prosecutors, okay. So by the Special Prosecutors Act Section 71 now 1 or say a person under investigation or charged with a corruption or a corruption related offense may voluntarily admit the offense and make an offer of restitution. Admit the offense means you plead guilty first. Again, admit the offense and offer to provide information that will lead to the arrest where investigations in the forum. So the word admit has been underlined. My culture says as flow from a constitutional provision of presumption of innocence. Because constitution, you know, until say obe proven ni pana guilty and no obe proven who guilty, you can never punish obi. So when kwasa wo kwaje admission of guilt, then what is the plea bargaining for? So this is what has been established here. Then 2020 Act 1019, your friend is saying Narcotic Control Commission, Narcotic Control Commission Act. Act 1019, Section 47. And also come by the no drugs and any related way. And for instance, one more cocaine transit and as for when away campaign, number moon we courier more, the small more, fako and ya chewa. Now we are ready. Say over my information, bet me cooperating with security in way. There is a plea bargaining there, which say, or no crowd and I are very certain. Say 20 years and as the mawa, or say, what me yes, I dear na, yama 10. And Joy say it is the only provision that provides certainty so far as this whole plea bargaining regime is concerned. Then we come to the mother of all plea bargaining, which is some regarded as a stand-alone act. Act 1079. But 1079 is an amendment to the Criminal and Other Offences Procedure Act, which is Act 30. na amend no man be kan ho kwan a proceed ye be fa so a ye be go through the prosecution, because your criminal your friends law no, there is other one a criminal procedure outline kwan a ye fa so step by step a ye didi asem no e ho hyehye ye nyina eno na ye amend ya ye insert a new clauses or provisions into it. I'm a catch say no stretch it from section 162A to section 162R, and also outline it. But you see, the point is that me can say you need to plead guilty. I am not saying say share negotiation na sia na so plead guilty. No. And yes, share until shasia no nipa na also be plead guilty in this case Wontumi no. Befra attorney general and attorney general na befra Wontumi na catch say chale baby a case na dru no. We don't want to see an answer say enti negotiate. So Wontumi will say I want to negotiate. Enti oni attorney general court no ma ho kwan omo 30 days to agree. So within that particular 30 days, if they are able to agree on something, details of it, our miru na agree, obi a me pese meko jail, me pese sika no bitua 30% na se for no. O man yes man, that is the negotiation phase. We no wunya nwie ye. Then after na wo court. Nti anopa no your friends enjoy. What I was saying is that before a court you need to plead guilty, not before your friend is saying attorney general, because even common sense will tell you say to plead guilty you plead guilty before a court of competent jurisdiction. Attorney general on your court na yakojine ni maka se medi for. Attorney general is not a court, so common sense alone should tell you say your case will plead guilty enye at the face when attorney general ye nhyehyeye, because attorney general anya court. You cannot plead guilty in front of the attorney general. It should be the court. So I think those who understand it really understand it. So makwa kodru court na mawie no, then the court will want to make sure say agreement na agree no eyawa wagye atum sa mpa eyawa. So court no be ma ya bisa o right ne na sefo ye be ready to you, so we ade no ye nyagye tum wi a you have no right to appeal o say ne twen ye wi a judge no will also have to make a determination o say twen ye be ready right nyina ma na yesa bisa say we sure say agreement na wo na attorney general sign ye no o signature wa na wo sign ye obi amfo so wo say ne twen na o say eyo ye wie enti free hakọ no ansana court no be koso aye de obeye bia no, you must first plead guilty. That is what is enshrined under the provision section your friend said 162H3. Before that, you need to plead guilty. Say u fail say dabi me appeal guilty and I say u appeal guilty a court no ed be kwa ne recordsum na watoa so a sentence wo. Na say oka say dabi me plead guilty a court no be ka say ebuo den plea na wo de aba ni nyina no withdraw. So common sense should tell you say there is no plea bargain that will go through the process ebe end without the accused person admitting guilt. We the intermine is simple ne say involve the state and your friends say Wontumi nko but oko act no ma in an instances where boneno against another person or your victim, the victim and the complainant must also agree. So it will become a three sort of negotiation between and your exceptions and then as a forma you don't negotiate. You only negotiate with the attorney general when your friend said those provisions has been established. Say these provisions your friend is saying you only negotiate with attorney general when there is when you won the state. But when other party are involved, that is what you do. And the Amaran so esi ho kwan, there are certain crimes and the plea bargain in kra. For instance, treason, high crimes, your friend say some felony, your friend saying rape, defilement. No, there is no plea bargaining in those kind of winning. Enti ansana obeka say wo plead guilty o answer na plea bargain be go through ama judge agi atom no science a sentence no so wo plead guilty there is no plea bargaining. And this what is a lawyers and then radio soon as for it's not an admission of guilt. Forget them. They are just politics and lying to people, buying convenience. My culture say, Kroma yetino, nipa nkanokre. And it doesn't matter who you are listening to on radio, TV. Say nipa no, esun legon nama, making sure say you do your independent verification to understand say nipa na some because politics inti. A man for to munim the atwapin and I the politics and or this is a simple thing that must be understood. But these people have deliberately twisted just to make say Wontumi no cry only for and Wontumi is not the first person I'll go for plea bargaining as for. In America, I can tell you, sir, if you look at their criminal justice system, about 90% of criminal cases in America, according to Way Institute Justice, is it Vivian Justice Institute? Almost 90% of all the criminal cases in America are resolved through plea negotiations. So a idea a coso by a harona we some way binti. So you must first admit guilt. So I'm telling you, sir, men kotie lawyer kuta jinibia or babia manen kokanchro say plea bargaining doesn't mean you are guilty. I have read the provisions to you. You need to plead guilty first. And son a judge in the sentence. And again, we are winning. If you go downwards now, kind of provisions now, Emran say, why any we are submitted or right to appeal everything to a judge, Then Mrasu say, judge ever sentence despite the agreement I want Attorney General no ajiatum no because judge jia na him in sentencing you the judge shall consider the agreement between, in this case, Wontumi and the Attorney General. And my culture says, consider is not an imposing phrase. Consider and yet imposing, but he will rather take into an account. Now I consider. So it doesn't mean that the mami no majiatum no, and then a court no kwajiatum no. The court maybe mubetimi aka say 30 million. Me pese me tuya 25 million. Me nko jail. Na ye fa ne say me de 1 year etua. We na mate ase wa plead guilty ne na sefo nyina. Judge no be man ruling na obetimi aka cho say da bi. Obetuya 25 million but obekwa akodam 2 years aka ho. Sika no de 3 years na betuya. So the judge can vary the terms because ono and our the power to punish or sentencing or none of what's out to me no Attorney General any to me why ya accusing wouldn't to me. So the judge even is compulsory because the word there is shall to consider, but consider doesn't mean adopt it. So he will look until Oshe law say, oh, my share we yes, 25 years, what you 25 million, yes, my dear 25 million about Kokodam, 4 years can Wontumi nya hoshe and ontiamara. That is the point that I want to make on this whole plea bargaining thing. So please, like I said, subscribe to this channel. Men kotena baby am obi nkotum futrongu so because kuta jene for no doso. Eno mu politics inti omu tum futuro ni na sefogu amamfo ani. Anytime I issue beba bia wa ankasa take your time and read and understand that one tiasia come to Ivan Che Innocent 1 this particular platform. We will tell you the honest truth. My culture is a plea bargaining me because of where we are over the years. So oma ho kwanya Kubi bini ye adipi benya bi ese no ye be ya se no ye de be negotiate ye find the crimes of people we think are special in society. Because I believe say the existing criminal justice system no see ye plea bargaining free ma eno ma ye ho kwan ma ye gi esika esanje liu. Eno ankasa in the ye fa plea bargain.
Dedi kama amena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.